All right, good afternoon and welcome to my YouTube channel. So we'll be continuing with contracts. Sorry, I have been away for some time. I've not really been having a lot of chance in order to be consistent with this my YouTube journey. Now, today we'll be looking at terms of a contract. Remember, we've concluded the elements of a valid contract, which are offer acceptance, consideration, intention to enter legal relations, and capacity. So if you've not watched it, just pause this video and go and watch it, because you must have to have the foundation of contract before going into terms of contract. Now, in simple terms, I'm trying to explain terms and I'm saying in simple terms, the play on words. Anyway, in simple language, you want to know the obligations you have in a contract. And the reason you want to know the obligations you have in a contract is because you don't want to go against any of the obligations. And so it is important you know the obligations you have in a particular contract. Now, these obligations are terms or can be terms, because of course, if you now want to differentiate it between terms and representation, that is when you say, okay, it can be terms, it can be representation. Now, these terms are still classified based on the degree of their importance. So there are some things, there are some obligations that you will go against. There are some obligations that you will not meet up to. And the consequences for that not meeting up to that obligation will be different from if you don't meet up other kinds of obligations. Now, the degree of importance is fundamental terms, conditions, inordinate or intermediate terms. Then you now have warranties. But we're not going into the explanation of nature of terms. The gamut of this particular video or the gamut of this particular lecture is to bring you into the field of terms, so that before we go into the nature of terms, you must first learn how to differentiate terms from representation. Now, if I may ask, is it everything that is being said prior to a contract that forms terms of that contract? Is it? Now, it is not for you to just answer yes or no. It is now knowing how to differentiate what is a term from what is a representation. Now, why is it important that we try to differentiate these and we try to know, okay, these are terms and these are representation, so that in the consequence of breach, that is, if you go against any of them, what happens? Now, for terms, if you go against terms, of course, you pay damages. It is more depending on the kind of terms, because of course I told you that they are divided by their degrees of importance. Now, depending on the type of term that you breached, if you breach a term, it's either it repudiates the whole contract or you are made to pay serious damages. Then some little damages if it is, the degree of importance is little, like warranty, inordinate and intermediate terms and all that. Now, but representation itself, if you go against a representation, that is, if you now go against representation, meaning that you now indulge in misrepresentation, of course that's the opposite here, then it is either you don't pay any damages or very little damages. So that when you are suing somebody that went against a representation, you are not suing for breach of contract, but rather you are suing for misrepresentation. Now, it is not different if the misrepresentation is fraudulent, because fraudulent misrepresentation, of course, will attract damages. Yeah? But then there are ones we call innocent misrepresentation. Then apart from innocent misrepresentation, there is still another one that was added just recently called the negligent misrepresentation. But now, like I said, our focus in this lecture is to know how to differentiate between terms and representation. If you're able to do that, we can now go into the nature of terms. So that your exams, when they bring it to your exams and they say, they will not give a scenario, you will not know, oh, this thing is representation and not terms. So in order to differentiate it, that is why we are here. Now let us get right into it. In differentiating terms from misrepresentation, there are tests that you will use in order to differentiate, that will help you differentiate them. Now, there are 5 tests in total. So the first three was propounded by Cheshire and Fifoot. These are authors, these are authorities in... It's now I now even know that authorities came from authors. Authors. Like we are an author in something, an authority. Wow. Okay. Sorry about that. Now, these are authorities in law of contract. They've authored so many books, in law, and especially law of contract. Now, Cheshire and Fifoot propounded the first three tests, while three tail, I don't know if I'm pronouncing that well, propounded the next two. So we'll go into these 5 tests. Now, if you know how to apply these 5 tests in order to differentiate terms from representation, then you are good to go. Any scenario you see in your exam, you will fight it head on. Because just place this test on them, you're okay. The first test is this. At what stage was the statement made? At what stage was the statement made? Now, how do we apply this test? So the first test is talking about when was this statement made, in order to know whether it's a term or a mere representation. And we say that if the statement was made at the preliminary section, at the preliminary times, before the contract was concluded, or before the contract was entered into, then it is taken as mere representation. And so this test also went ahead to say the time lag, if the time lag is long from when the statement was made to when the contract was entered into, then it is mere representation. But if it is shorter, you can see it as terms. Now, this particular test has not really been consistent with the decisions we have on these subjects. Because take, for example, in Showell against Reed, you have to read the case yourself. The particular statement was made 3 weeks to the conclusion of the contract, but it was taken as a term. While in Rutledge against McKay, the statement was made 1 week to the conclusion of the contract, but it was taken as a mere representation. So you see that it is not really consistent like that with the decisions we are having this period in law of contract on this subject. So, but that is the first test. Notwithstanding that it is really not consistent, you must have to know it as a test in order to differentiate between terms and mere representation. When was the statement made? The second one was the statement reduced into writing immediately it was made. So the idea here is if it was just stated and it was not reduced into writing, then it is just mere representation. Only the ones that are reduced into writing are the terms. But just like the first one, this one is also really not relevant. Not really relevant, but it has not really helped in reaching a particular decision by the courts. Yeah, but Cheshire and Fifoot, these are their tests, and you might see a scenario-based question in your exam that would incorporate this test, and they will now ask you to differentiate or to state if it is a term or it is a representation, a mere representation. So you now know the test you use, especially when they talk about writing and it was not reduced into writing. Which one is term, which one is representation? You know the test to use. Now, the third test, this one is the best and it has always been applied, is one party's superior knowledge. The idea here is if the party that is making the statement has superior knowledge of that particular subject matter than you that they are making the statement to, it becomes a term of a contract. However, if that the statement is being made to has superior knowledge than the person making the statement, it is seen as a mere representation. So what do I mean? You are a car dealer. You know so much about cars. In fact, you studied automobile engineering and you are dealing on cars. And I come to your car shop to buy a car, and you now tell me that take this car. This car is the best. It will never spoil in 2 years because of, you now say some kind of technical things. The carburetor and the alternator is inside the relator and was imported from China. It is this one. You now said all these things and I believed you because you have superior knowledge than I do Then I now, because of what you said, bought the car. Yeah? And the car now spoiled within 2 months. I can sue for a breach of term. It is a term of a contract. That statement you made is a term because you had superior knowledge than I do. It's a term. But if I wanted to sell my used car, I have finished driving the car, I want to sell it to you that is a car dealer, and I told you, I now explained to you that this car is very good because the alternator and this one, that one, that one, this one. I don't know anything about car. I'm a lawyer. You are the one that knows something about car. You now relied on what I told you, the information I gave you, to buy the car. Me that I don't know anything about car, you that you are a car lord. If that car now spoils before the end of 6 months, maybe I told you that the car will never spoil in like 2 years, and it now spoils by 6 months or 3 months, you cannot sue me for breach of term because it was not a term of a contract. It was a mere representation because I did not have superior knowledge than you do. So what you will sue me for is mere representation. And I can even claim it is innocent representation because I don't know anything about car. It's not fraudulent because if I had known anything about car, I wouldn't have really said what I said. So it's mere representation, and you might not even get any damages for that. So one party superior knowledge, it has been applied in that Showell against Reed I told you, it was applied there. So even though the 3 weeks time period was so long, it still was a term because it was something that came out from somebody that has superior knowledge. So go and read the case, it will help you. So these are the 3 tests of share and fifut. Now I told you that 3tel added 2 additional tests. Number 1 is verification. Go and verify. So if after I finish telling you something about a particular product and I tell you, you can go and verify. Now remember that normally, me as a superior person that has superior knowledge, if I tell you and you rely on it and you buy, it is a term of a contract. Now, but if I want to now remove that, if I want to now differentiate, remove terms from that, I will not tell you go and verify, because if I tell you to go and verify, it will now no longer be term, because I gave you the opportunity to go and verify. So you are not now entering into that contract based only on the reliance of my information. I have told you to go and verify. So even if you verify, you don't verify, you cannot now say that you entered into that contract because of what I said, because I asked you to go and verify. And that go and verify has removed that toga of terms. It is now mere representation. Where it will be a term is when I tell you, I don't need to verify now. Is it not me? I am a very great, one of the greatest automobile engineers in this world. And I've told you something, just take it. It's nothing. So it becomes a term. Like it remains a term there. Because you are not given the opportunity to go and verify. But when you are given the opportunity to go and verify, it is a mere representation. Now, another test, of course, even though they are a little bit, interrelated, is the degree of importance the representee attached to the statement of the representative. The degree of importance. So, if I did not want to buy something, and because you said something that made me to buy it, and I bought it because of that thing you said, it is a term of a contract. Now, I don't mean to attack any religion, but let me just use this as an example. So we heard, I've not read the Quran before. I don't know what the Quran says about it. But we heard that when once you eye in the course of serving Allah, in the course of serving God in the Muslim faith, you are going to paradise. Is it paradise they call it? I don't know what they call it in their Arabic language. And you'll be given some virgins. Some virgins to be with you in paradise. So now, ordinarily people might not want to buy in the course of serving Allah. They might not want to on their own. But because they have seen, or maybe one of them are one that like women too much, I've said, okay, so if I go and serve Allah and I die, if I die, I think some virgins will be. Now, because of that promise, the degree of importance to which he now relied upon to perform that thing. Because without that promise, he wouldn't have done it on his own. So that is how this one is, this particular test. So when there is this degree of importance put on these statement. In that without that statement, this person would not have gotten this thing. Then it is a term of the contract. So that is it. Now let's go into collateral contracts. Now collateral contracts will take some form of inference from the last test that I just explained, which is the degree of importance you place on a particular statement in order to enter into that contract, so that when you want to sue for the breach of that statement, you now sue for breach of term of the contract. Now, collateral contract. Let us say that I have promised you, just like the car, buy this car, it is one of the best and it can drive from 0 to 60 in 20 seconds and it will not spoil in 2 years. And you relied on my statement. You put a lot of importance or degree, and I even told you, you don't need to verify. It's me that is saying it, it's coming from me. And you relied on what I've said and you've purchased this car. Now, if this car spoils, did you know that there are 2 contracts there? There are 2 contracts. Number 1 is the promise that this car will not spoil. Yeah? Of course, when you look at the definition of offer, you now see that offer can be a promise. But in order for it to be binding, there must be, of course, acceptance and consideration actually. Your elements of contract. You see why you are supposed to do your elements of contract before watching this one. Now, if I make a promise to you, for it to be binding on me, you must have furnished consideration. Yeah? And we looked at the different types of consideration. And we saw that we have executory and executed. Follow me, oh. Executed consideration being that consideration that you will have to do by performance in response to a promise. So if you made a promise and on that promise, you said, if you buy this particular thing, it will not spoil for 2 years. You have made a promise. And I rely on that your promise and I bought that thing. Buying that thing based on what you have told me, based on your promise, is consideration to your promise. And so I have furnished consideration by buying that thing. And so the promise that you made, that this thing will last for 2 years before it spoils, is now binding on you. And so I can sue you for collateral contract, for breach of collateral contract. Now, in the case of Wells Mesham Limited versus Buckland Sand and Silica Company Limited. So in this case, very simple, very interesting case. Somebody that is selling sand, that is manufacturing, let me not say manufacturing, he is actually the person bringing the sand and treating the sand, has represented to somebody and said, this particular sand does not have silicon. So it will make your crops to grow faster. And this representee, the people that want to buy the sand, did not now buy from them. Of course, it was still their sand, but they bought it from another distributor. Yeah, they bought it from a third party, but it is this company's sand. Now, when they bought it from that third party, they found out rather late that it had silicon, and their crops that they planted on the sand has all withered. Now, they did not sue the people that sold the sand to them, because they just sold sand to them. These are third party members. They sued the company that actually told them that this sand was good for their crops, based on collateral contracts. Now, in the case of City and Westminster Properties Limited against Mod, what happened in this case? Very interesting case also. They wanted to renew a lease. This is a building. But in the new lease, they now put a clause or a covenant that all the rooms or all the spaces in this particular building should only be used for office spaces, should only be used for shops. So, in fact, the whole idea is so that nobody will be sleeping over in that particular building. Like, it is not a residential building, but a commercial building where people will come to their shop or come to their offices and go. It was in the lease. However, Mod did not want to sign the lease because this was where he was sleeping. He said, if you say I will not sleep here, That means I should go and look for house or another place. There's no need signing this lease. Now, the owner of the company or like one of the managers or something now told him that, see, if you sign this lease, don't worry, you will still be sleeping in the office. Just sign the lease. Now, based on that promise that, okay, if I sign this, even though it is written in the contract that I'm going to sign, that nobody will sleep in the office, but because you have promised me, no problem, I will sign it. Based on the promise that was made, he signed the lease. He started sleeping in the office. They now sued him that he has gone against the covenant in the lease, expressly stated. But based on collateral contract, the court held that even though he has gone against the express listing, he is entitled to be sleeping there because there is a term of a contract, and based on collateral contract, that is a collateral contract, that he should be sleeping there because of the promise. The promise has been made. He has furnished consideration by entering into contract, because without that promise, he wouldn't have entered into that contract. And so that promise made and the consideration furnished, acceptance taking place, consideration furnished, becomes a contract on its own. That's a collateral contract precipitating into a contract of lease. I hope you understood this collateral contract. Collateral contract, you need not a separate consideration to furnish or to make the promise binding. Only entering into a contract because of a promise made is enough consideration to that promise made. Yes. So, when next we come, we'll now look at the nature and the categories of terms and the consequences of breach of any. Thank you very much. I remain the law professor. Got it.